So I'd just like to thank Alistair Kelman for joining us today to discuss online harms, in particular the work that he has done in this space. So I will now hand over to Alistair, and at the end we'll then take questions via IRC chat. So Q+ to line up on the queue, you know the score. Thank you, Alistair.
Thank you, James. Good afternoon, everyone. To put everything in context today, I better say a bit about myself. I used to practice as a barrister, but I left the bar to concentrate on technology and patents. I started out working in technology and law back in the days before TCP/IP eclipsed the open systems interconnection standards. I have a personal website, and on screen is the best email for you to contact me today after this session. Today, I work via the SafeCast company that I co-founded with my wife, Diana. We're working on protecting children from being harmed by content on television and the internet. We have two websites, safecast.co.uk and Safecast Global, which we invite you to visit. Safecast Global is the home of our non-commercial initiative in child protection, and we would like you to look at this, and if you so wish, sign the petition we have drawn up on change.org. I want to distinguish today between two types of online harms, since we're only going to be addressing the first of these today when looking at the UK and the European situation. This is harms by content on the internet. Viewing the content causes harm to the viewer. But there's a second group of harms, which are things like child abduction, coordination of criminal activities, criminal conspiracies, organized crime, and terrorism. The first group of harms are addressed by particular government departments and regulators, the UK Department of Digital, Culture, Media and Sport, DCMS, the Information Commissioner's Office, and Ofcom. Also, the UK Department of Health and Social Care deals with the mental harms that arise from viewing content. The second harms fall within the scope of the National Crime Agency, the Home Office, and our security services, GCHQ. I'm not going to go into these harms today, save for saying that my wife and I have put our proposals before these agencies, and it would appear to be the case that they consider our proposals to be either beneficial or neutral. So, long ago, online harms arising from content were considered by the W3C. There are links in my presentation afterwards, so you can check on anything afterwards. In the early 1990s, the W3C drew up a metadata standard to protect children. It's called PICS. And in 1999, PICS was superseded by POWDER, the Protocol for Web Description Resources. This was far too complicated. It tried to integrate search engine capabilities in child protection. It had a commercial cost, around $40 per device per child, which was, in those days, thought to be acceptable. It had serious censorship issues because there was no consensus amongst the members from the W3C on how it should be used. It had database design issues. They separated the content from the labels themselves through pointers. A very sensible database design issue, but it meant that some of these things got lost. But the thing that finally wiped it out was when they took the basic standard and enhanced it with quality marks. Is this a good website or not? This led to the standard being taken over by astroturfers and search engine optimizers to push their websites up the ratings agencies. By 2005, the standard was effectively dead, and PICS and POWDER were abandoned around 2008. Looking now at the legislation in this area, the key piece of UK legislation is the European Union Audio-Visual Media Services Directive, and specifically the AVMS-D regulations, which strictly speaking come into force on 1st November of this year. Following on from this new legislation is the Age-Appropriate Design Code, which comes into force on the 1st of April of next year. Then we have the Online Harms Bill, which is to be published early next year and should be in full force by the end of next year. And finally, we have the new European Commission Digital Services Act. The consultation on this closed in September. It's at a very early stage, and I estimate it will come into force about 2024. Now, the AVMS-D is the responsibility of the UK Department of Digital Culture, Media and Sport, and is enforced by Ofcom, the telecommunications regulator and online harms regulator. The age-appropriate design code is the responsibility of the UK Information Commissioner's Office. The Online Harms Bill is being brought in by the UK government, and the Digital Services Act is being brought in by the European Commission. All these pieces of legislation are based around a simple point. Children and vulnerable people need protection from being harmed by content on the internet without censorship. And my case today is that the W3C can make this happen. With your help, we can bring in effective protection within months, not years, through the use of open standards. At the end of these discussions, I hope you can tell me what groups and forums does the W3C have to support the European legislation and preserve what are termed family-friendly filters for parents. Something we've all experienced is that legislation runs behind technological change. Regulation of audiovisual works in the European Union was based upon the Audio-Visual Media Services Directive, which became a directive in 2010 across the entire European Union. This directive ensures that broadcast television was highly regulated. Now, broadcast television is things like the BBC, ITV, Sky, Channel 4, RTE, Canal+, RTL, ORF. But on all those systems, content which might harm a child is banned. But on-demand content, which in those days was little more than a few premium television channels on cable television channels on satellite with a very small number of viewers, was made subject to a less rigorous regulatory regime. Specifically, pornographic satellite and cable channels lobbied Brussels for a less onerous regime. Then along came YouTube, Facebook, Twitch, and TikTok. 5 years ago, the European Union drew up a revised Audio-Visual Media Services Directive, which was passed in 2018. This brought everything within the same standard and content, so that content which might harm a child was banned on both broadcast and on-demand video. It's a pan-European directive, and every country in the EU and the UK was required to bring in new laws to bring it into effect by September 2020 at the latest. Then, yes, which of course has impacted every single country in the EU and has made it impossible to meet this deadline. Turning now to the UK position, we are actually the first of the EU to bring in the new law, to bring a new law into effect. The new law is set out in the Audio-Visual Media Services Directive, and content which might harm a child is banned on both broadcast TV and on-demand video. It's in effect from the 1st of November 2020, but it's not going to be actively enforced before the 1st of April 2021. Instead, Ofcom, the regulator, has recently had a consultation on the subject of the regulation of video sharing platforms and online harms, and the Ofcom report is awaited by everyone with interest. Under these new regulations, video sharing platforms must enforce their membership requirements. That's the click-wrap agreement to protect children. There must be no harmful or misleading advertising. There must be no harmful content. They must age verify their users. They must also register with Ofcom, they pay the fee and accept UK jurisdiction over content to UK citizens. The first issue is how VSPs are going to comply with the new Audio-Visual Media Services Directive regulation to remove harmful content and advertising. They appear to be intent on doing this through the use of artificial intelligence and databases to filter away anything that might breach the regulations. How do these systems work? The main ones are Google Safe Search and Semantic Rule Space. Both of these use proprietary AI and database systems, and because these are proprietary systems, their operations are not public. Ofcom, in their VSP consultation, which closed last month, asked some very detailed questions of VSPs. And it will be looking at how VSPs, artificial intelligence database filters, comply with Ofcom's core principles, core requirements of freedom of expression and transparency. Now, while this area is the major, within this area, it's the major problem for family-friendly filters. Semantic Rule Space and Google Safe Search are core parts of family-friendly filters in the UK, something that parents depend upon. 90% of UK families get their broadband from 4 internet service providers. All 4 of these ESPs have family-friendly filters on by default. All mobile networks in the UK have family-friendly filters. The big retailers where children are present, like McDonald's and Starbucks, also have family-friendly filters. The Internet Watch Foundation provides a DNS list to block child sex abuse material to these family-friendly filters. But new Internet Engineering Task Force protocols undermine the operation of these DNS filters. There's no solution yet offered by the Encrypted DNS Deployment Initiative members, as I'll explain on the next slide. To protect security, new IETF Internet Engineering Task Force standards are coming in. These are essential to protect the operation of the Internet against threat. Privacy is being embedded within the Internet so that communications can be private and to inhibit stalking and abuse. The technical changes are being rolled out by Google, Apple, Mozilla, Cloudflare, and Comcast, who are key members of the Encrypted DNS Deployment Initiative. These will protect against man-in-the-middle attacks and make it less easy for governments to censor the Internet and for attackers to stalk users' online behavior. These changes are coming in during this year, but as an unintended consequence, our family-friendly filters will fail. It was for this reason that the IWF asked me to sit in on the EDDI discussions to suggest how EDDI members could address this problem. I want now to briefly outline how we can regulate the Internet. We can do this using laws, but we can also do this using practices. Laws go through a series of steps. Laws are made by Parliament, bill, second reading, committee stage, yada, yada, as you know, all the processes we go through. They're lengthy, expensive, difficult processes, there are many loose ends, and they can be lost in going through the legislative processes. They also can have unintended consequences. Waiting lists for medical appointments are a well-known example of how the certain hospital boards gamed the system to get themselves supposedly in compliance. Also, laws are difficult to interpret correctly, and from time to time we need judicial review of a law. So it's not a straightforward process. In contrast, practices are made by merchants and the business community. They're experimental means to lead to a desired result. An established business practice can become a law via judicial interpretation and case law. That's what happened over the centuries, effectively, with double-entry bookkeeping. And a modern example of a practice would be the placing of adult magazines on the top shelf in a newsagent as a means of stopping young children from perusing them. It's not a law, but it's a best practice. And practices can become universal by the network effect as more and more people use them. It's particularly good examples of this are the QWERTY keyboard, which has embedded itself in our lifestyle, and GSM phones as well. So, there's a way that the W3C could help. This is Larry Lessig. He's a professor at Harvard, and Larry's a great thinker on human rights and copyright. He's the person behind Copyleft and the Creative Commons. Just over 20 years ago, he published a book called Code is Law, which looks at how computer programs and logic could be made to embed laws in systems which we humans use and rely upon. His work has inspired me and has led me to set out the SafeCast proposals, which are to use global standards as a proxy for legislation to regulate the internet. I now want to tell you a bit about how we got to where we are. Back in 2012, the embryo of our SafeCast company started looking at content labeling on the internet to protect children. We started from a different place than the W3C. We looked at how the Independent Broadcasting Authority, the predecessor to Ofcom, regulated television in the 1960s and 70s. Through our early work, my wife and I came up with a notification standard, which was equivalent to the television watersheds. And we put our proposals before the European Commission and Ofcom as the basis of a self-applied content labeling system, initially as a best practice. We found that all video could be divided into just 7 classes, from video which was suitable for anyone to watch, to video which could never be broadcast without restrictions, such as execution and beheading videos. We also found that our classifications could be mapped onto the key stages of the national curriculum, which means that generic age filtering based upon the school age of a child can be used in digital devices as the basis of filtering for child protection purposes. In 2013, we were granted a UK patent for our invention. The claims only apply to automated filtering in advertising, which allows our invention to be used completely free of charge for automatic filtering of content, which is not advertising. Now, if you think of content as something, as a continuous spectrum, then there are colored areas which fall below it. There'll always be a debate about whether something is blue-green or green-blue, and thus whether a piece of content falls within a level 2 or a level 3. But onto this, you can impose fixed bright lines for advertising, which ensures that inappropriate advertisements are not shown to children who are too young to view them. In 2016, we got a US patent for our invention. In the USA, the TV watershed is called the Safe Harbor Rules. And also in 2016, SafeCast gave the UK government a FRAND undertaking, that's fair, reasonable and non-discriminatory, so that our patents could effectively be standard essential patents. This is a bit like your mobile phone, which has thousands of patents involved in its operations. The final barrier to our universal adoption was removed when the UK Intellectual Property Office notified us that it was prepared to act as a mediator on determining royalty rates. So in 2018, the Office of the Children's Commissioner asked SafeCast to approach Facebook with our proposals. It was already a means of coding filtering in YouTube in its APA, under which BBFC videos could be classified in YouTube metadata. This is the code for all those programmers amongst you. Very straightforward. We proposed a similar code for SafeCast, the SC/HC heads codes, which we knew could fall within the ISO standard. This is what we put up to Facebook. And Facebook has yet to respond. I spoke some time ago about how laws and practices, and how practices can turn into standards. Well, today's standards enable seamless mirroring between devices. This is all done through embedded metadata. With one flick of a finger, you can send a video from a mobile phone onto a 4K television screen. All the complex changes are done by interoperable standards. In video, this is done by 2 organizations working together, the Digital Production Partnership, which we're members of, and SMPTE, the Society of Motion Picture and Television Engineers, which have their standard on a thing called GitHub as TSP 2121. This is the full name up there. Also in this area is IDA, the Entertainment Identifier Registry, which is based in Hollywood and looks after ISO 26324, the Universal Digital Object Identifier System. This has the inbuilt capacity to cope with all possible and potential video content created by the human race forever, allowing child protection through metadata labeling and filtering to become a core part of every video without censorship. Protecting children and vulnerable people on the internet is not just about pornography and censorship. There are other issues at stake here too, fraud and crime. On 1st April 2020, the Age Appropriate Design Code will come into force under Section 123 of the Data Protection Act. This code says that all advertising must comply with the Committee of Advertising Practice Code, the CAP code. The CAP code is an industry standard which is self-regulating and forms a core part of the regulation of broadcast advertising in the UK, which must be legal, decent, honest, and truthful. These are the requirements built into the CAP code. Under the code, the ICO has ordered that all advertising must contain details on ownership, that is, who owns the advert and is promoting it, provenance, where the advert is coming from, and product placement, identifying that the advert is an advert. These requirements do not cause any problems for UK regulated broadcasters like ITV or Sky or Channel 4, but they are serious problems for Facebook, YouTube, and Twitter, who do not have this data. In my slides, there are two hot links, which can take you to major news stories from the Wall Street Journal and the New York Times, which show how the situation is out of control. SafeCast has put forward some proposals. We're saying that to adhere to the CAP code, all advertising must contain metadata on ownership, provenance, and product placement so that it can be filtered away for child protection purposes using the provisions of Section 104 of the Digital Economy Act. That's already law. And we're also saying that to enable lightweight content filtering without censorship, all content, including advertising, should contain SafeCast head codes to enable open standards-based lightweight filtering for child protection purposes. We're waiting on Ofcom's response to our suggestions. But if we're successful in getting our proposals taken up, then as a bonus, it will mean that metadata labeling within an open standard can protect the family-friendly internet in the UK and the EU. Furthermore, because of the capability within ISO 26324, the Universal Digital Object Identifier System, the labeling can be implemented nationally in accordance with the digital sovereignty requirements of nation states. There will be no need for Google, Mozilla, Facebook, Apple, Cloudflare, and Broadcom to become global censors. There's a relatively new legal concept in international law called digital sovereignty or tech sovereignty. It allows nation states to harmonize technical issues in a consensual manner. It allows us to give effect to good technical engineering and business practices, which improve trade by removing barriers to trade, increases the volume of trade, and it improves safety. Picture on the right is Dr. John Postgate, a Birmingham 19th century doctor who campaigned for over 20 years of his life for legislation to stamp out the practice of adulteration of food and medicines in the face of powerful vested interests and the indifference of most parliamentarians. Today, the unfiltered internet is a polluted sea of information mixed with disinformation, pornography, horror, and violence. Filtering the internet to protect children from being harmed is a universal public health issue akin to food safety and the provision of clean water. I ask for your support for SafeCast proposals and your guidance on how we can get the W3C behind these. Thank you for your attention.